All right. I will take that, Angela. I guess we are set to go. So, and I'll ask all the panelists to turn on their yes, cameras again and speakers. So, welcome everyone to today's panel, which concerns the role of the judiciary in assessing the judiciaries and legal systems of other states, with a focus on China. So I come to you not from New York, but actually from one of my other venues, my office at Princeton. And that is relevant because I got the idea for this panel from a paper presented at Princeton by one of our panelists, Don Clark, who was then a LAPA fellow. And he was looking at precisely this issue with regard to China. And I thought, especially given at least my interest in the role of the judiciary in foreign affairs, it was a great window both into that topic and into issues with regard to China. So with that in mind, we have a fantastic panel to explore these issues. And let me introduce them briefly. So we will start off with Don Clark, and I will keep these introductions super brief. Don is a specialist in Chinese law as GW Law School, if you couldn't figure it out from his background. He, among other things, runs, and I'll give him a plug for this, a fantastic listserv called China Law, which is open to all and has some very good, lively discussions. Next will be my former colleague at Fordham Law School, Mark Cohen. Mark currently heads the Asia IP project at Berkeley Center of Law and Technology at Berkeley Law School. Berkeley's gain was certainly our loss at Fordham. And he's also responsible for teaching international trade law and research and IP issues. Previously, he was a senior counsel at the Office of Policy and International Affairs at the US Patent and Trademark Office. And like Don's, his accomplishments run on and on too. After that, we will have Vivian Bath, who is a senior lecturer in law at the Faculty of Law at the University of Sydney, and director of the Center for Asian and Pacific Law at the University of Sydney. She teaches international business law, doing business law in China and Chinese laws and the Chinese legal system. And then last but certainly not least, we are fortunate to have Tsuyi Li, who is currently a postdoctoral fellow at the National Taiwan University, Ministry of Science and Technology in Taiwan. And she has been an intern at the John Marshall Law School Trademark Clinic and at the United States District Court for the Northern District of Illinois, as well as the Holocaust Art Restitution Project, among many other posts. So our format is going to be fairly standard. I have asked each of the panelists to speak for about 10 minutes with initial remarks. And then after that, depending on how things go, we will either have a brief colloquy amongst the panelists, or more likely just simply go to Q&A to you, the audience. Towards that end, what I would ask you all to do is, if you have a question, just simply state that you have a question in the chat. You don't have to say what the question is, just say that you have one, and then I will go through all of your questions in the order that you submitted your submission of questions in the chat. So without anything further from me, let's get things started off with the expert who actually stoked at least my interest in this topic, and I'm sure he will stoke everyone else's in this interest in this topic as well. So let me turn things over to Professor Don Clark.
Okay, thanks very much, Martin. In my presentation today, I want to talk about some research I've been doing on how US courts look at the Chinese court system. The inspiration for this was my experience as an expert witness, in which I found something very odd that although, if you read the mainstream media, New York Times, Wall Street Journal, Washington Post, anytime they talk about the Chinese court system, they say, it's dominated by the party, there isn't an independent judiciary, and yet the message doesn't seem to have gotten through to federal and state judges who routinely treat the Chinese legal system, at least by default, as if it were kind of the legal system of Canada. So there's a lot to say. I've only got 10 minutes, so I'll just really be skating on the surface of the surface of the surface. But let me share my screen to start my slideshow. Is that showing up for everybody?
Yep.
Okay. So when US courts, face Chinese law issues, what are the occasions they do it? Well, for example, somebody says, I want you to enforce this Chinese judgment. And then forum non-convenience motions is another big occasion. There's also things like they have to look at Chinese governments or party statements about what Chinese law is. Just don't have time to cover that today. I'll just be doing the first two subjects. So enforcement of Chinese judgments. Typically in the US, it's a state court matter. Even if it's in federal court, it's a federal court sitting in diversity jurisdiction and applying state law, almost always. And states typically have one of two uniform acts. There's one from 1962 and one from 2005. And generally the procedure is the plaintiff has to show that there is a judgment, that it's final, conclusive, and enforceable. That's not a tough burden to meet. And then the burden shifts to the defendant, who doesn't want it enforced, to show that it was, in the words of the 62 Act, you can see, rendered under a system that does not provide impartial tribunals, that there's some kind of, due process problem, basically. Then there's some discretionary grounds that are based not on the quality of the foreign system, but on the quality of the case itself. Substantial doubt about the integrity of the rendering court with respect to the judgment, or again, not compatible with due process. So that's a very brief outline of kind of the standard that's applied. But as you can see, it does require the court to make some kind of a judgment about the quality of the foreign judgment. I collected every case I could find. I found 14 cases from 2009 to 2021. And my focus was not so much on who won or who lost, although that's important, but looking at the quality of the arguments made about the Chinese legal system. I should say that in researching this and in also researching the forum non-convenience cases, I did not look only at the judgments, but I went into the Bloomberg law system, which takes documents from the PACER system, so I could get access to all the briefs of the parties and look at the expert witness statements, if there were any, the briefs submitted by the lawyers and stuff like that. So I had a pretty thorough idea of what kind of evidence and arguments the judges were seeing. So I found actually that most cases were decided on grounds other than arguments about the quality of the legal system. But basically, I found that if you were sort of looking for precedents that were favorable to enforcing Chinese judgments, there were 6 cases. If you were looking for precedents unfavorable, there were 5 cases, and kind of neutral was 3 cases. The interesting thing is the 6 favorable cases were actually not that strong as arguments in favor. They weren't very strong as precedents if you looked at them closely. Why? Well, 2 of them were default judgments, so obviously that doesn't mean anything as a precedent. And in 3 of the remaining 4 cases, the defendant had previously argued in forum originally the plaintiff had sued the defendant in the US, and the defendant had said, no, forum non-convenience, go to China. And in forum non-convenience arguments, the defendant says, sue me in China, the Chinese legal system is fine. The plaintiff obviously says, no, it's terrible, but the defendant says it's fine. So they got sued in China, they lost. The plaintiff comes back and tries to enforce in the United States. And obviously at that point, the defendant cannot say, oh, the Chinese legal system is terrible. So they are either, formally or at least informally prevented from making any kind of strong argument about the lack of quality of the Chinese legal system. And then in one case, it was just issue preclusion. It wasn't enforcement of the judgment. So really, in 5 of the 6 cases where recognition was granted, then the defendant either could not or did not mount any kind of substantive defense relating to the quality of the Chinese legal system. I also found that the evidentiary basis for the decisions, did they have expert testimony? Did they cite, well-known works about Chinese law by, good scholars? No. So little genuine inquiry into the Chinese legal system. Okay, moving on to forum non-conveniens. The premise of forum non-conveniens is that the court has jurisdiction over the defendant. They could try the case, but the court in its discretion can decide to grant a defendant's motion to dismiss on the grounds that the plaintiff should sue in some other jurisdiction. So in all these cases, the defendant's saying, don't sue me here, go ahead and sue me in China. And the official doctrine here says that for the motion to be granted, the foreign forum has to be adequate and available, and that's pretty easy to satisfy, it turns out. If those requirements are satisfied, then the court weighs the public and private interests. But there's another element to the doctrine, at least the official doctrine, which says that the plaintiff's choice of forum, should rarely be disturbed. Now, what's the reality? The reality is not just China, but all over, and I'll talk about China specifically in a moment, but kind of across the board, grants of forum non-convenience motions run at about 40 to 50%. So clearly that last bit of the doctrine is being ignored by courts, but of course, courts don't have the big picture at hand in any individual case. A court might say, "Well, I'm only granting it rarely, but this is one of those rare times." But it turns out actually it's not rare. So in my data set, I collected, hand collected all the cases I could find in the post-Mao era, going through to about November 2020. And I came across 53 cases for various reasons. That actually ended up as 55 motions in 53 cases after making some exclusions for various reasons. So it's not a gigantic sample, but I think it's a pretty good sample on which, not a sample, it's a universe of cases from which to draw some conclusions. The first finding is that the dismissal grant rate is very similar to the overall rate, 40%, so not rare. Second is that state courts are more generous than federal courts in granting forum non-convenience motions. You can see granted is the blue, granted is the dark green, denied is the blue, and federal courts, deny, almost 2/3 of the time, whereas state courts less than half the time. No obvious trend over time. I was thinking I would find one. That perhaps as courts became more familiar with China, as China seemed, more marketized, more kind of open, that we would get some difference. But in fact, you don't see, at least it's not obvious to me that there's any trend visible over time. China, where the motion is granted, obviously China has been found adequate just by definition, because if it's been found inadequate, you can't grant the motion. But it wasn't always disputed. In cases where the adequacy of China as a forum was disputed, in a majority of cases, it was found adequate by the courts. So that would be when it was found inadequate when disputed, that's the gray there. So you can see it's just a little over 25%. So when it was disputed, people who disputed it didn't do very well. One thing really interesting I found was that the quality of evidence offered in the cases does not seem to have made any difference to the outcome. And I calculated this thing called expertise differential, which meant that I looked at the quality of evidence offered by the two sides. In other words, did they offer any arguments or evidence at all? Sometimes they didn't. Sometimes it was no more than just a line in a lawyer's brief saying, China is clearly adequate or China is clearly inadequate. At the other end of the spectrum, you would have, an expert witness report by a tenured professor of Chinese law somewhere, either saying that China was inadequate or China was adequate. And so I then kind of scored the quality of evidence, again, subjective, but that's all one can do. and then calculated an expertise differential of the quality of the movant's evidence minus the quality of the opposition's evidence. And here's the result, granted in blue and denied in orange. And you can see that, take the last one on the far right, movant's evidence minus opposition's evidence was overwhelmingly large. It was a score of 4. And yet we see most of the cases were denied when the movant's evidence was the strongest relative to the opposition's evidence. So obviously other things going on there, but it seems to show that hiring an expert to testify does not do you any good on either side. So both sides could save the money. So what are some of the problems here that this shows? One thing I found in the cases was that, both sides, particularly the sides moving for dismissal on forum nonconvenience ground, would have these long string citations, which, obviously cannot all be read or are unlikely all to be read by the judge hearing the case. And then you get this kind of lock-in effect of prior decisions. In particular, there's one case which is kind of the poster child for a miscitation of a case, and that's a case called Sinochem, in which a district court dismissed to China on forum nonconvenience grounds. Obviously, in the course of that dismissal, they must have found China adequate. But that finding of adequacy was not appealed. What was appealed was a completely different issue, a technical civil procedure issue, basically of whether you had defined personal jurisdiction before you decided the forum nonconvenience issue, or whether you could decide forum nonconvenience before deciding personal jurisdiction. That was the issue that was appealed. That was the issue that went to the Supreme Court. The Supreme Court did not hear any arguments or evidence about the quality of China, the adequacy of China as a forum, and yet it is routinely cited in movants briefs as saying that the Supreme Court has, held or has found that China is an adequate forum, which strikes me as at least unethical and really outright dishonest. So what's the kind of summary of it all? I guess the enforcement cases are interesting because the courts very often say things like, well, we don't want to be in the business of passing judgment on foreign legal systems. They seem to think that it, violates principles of comity for them to, assess the quality or to say anything bad about a foreign legal system. This strikes me as strange because the doctrine, requires them to do that. It requires them to assess whether standards of due process have been met. And to refuse to pass judgment is simply to hold that this element is always automatically satisfied. On forum nonconvenience, there's a number of critics who think the doctrine, at least in the international context, should be abolished. And I think the Chinese cases show that the critics are correct, because the China cases show that in practice, the courts do not and really cannot make these kinds of judgments about a foreign legal system that the doctrine requires, and courts are certainly not granting it rarely. And what's kind of interesting about, the movant's briefs here is that by this kind of forensic jujitsu, right, they will cite a long string of cases where the motion was granted and use that to try to convince courts that they should do something which the doctrine requires to be done rarely. They say, look at all these other courts that are doing this rare thing, so you should do it too. So I think really forum nonconvenience, kind of should be abolished in transnational cases because courts just, can't figure out a foreign legal system. And then finally, this kind of really interesting thing is that, although the Chinese government, in many of its communications makes it clear that it thinks the US government is kind of incorrigibly biased against it. But actually, we find that this one very important branch of the US government, the judicial branch, their default position is typically that the Chinese legal system is really just like the US legal system. And the burden is, and it's a very heavy burden, is on the party arguing that it is not. Okay, so I'll stop there because I think my time is up, but thanks for listening.
Okay, great. Thank you very much, Don. And now we will turn things over to Professor Mark Cohen. Thanks, Mark.
Thank you, Martin. Thank you, everybody on the panel and people listening. It's a pleasure to be here. And I wish we had a lot of time. I'd just like to engage Don on a whole bunch of his observations, particularly as they apply to what I'm about to discuss, which is really not exactly a court, it's the WTO, and how the WTO has evaluated the transparency obligations of China to disclose intellectual property related cases in under Article 63 of the TRIPS agreement, the agreement respecting intellectual property. Before I show my slides, just a little bit of background. So these cases, and there have been several of them since 2020 in China, involve anti-suit injunctions. So China decided that it had the authority under civil procedure law to enjoin the prosecution of cases overseas without regard to territoriality. That is, they could say to a British court or a German court, you cannot consider, or an American court, you cannot consider issues involving patent infringement in their jurisdiction by virtue of an anti-suit injunction. The ASIs have been issued in different ways, but a couple of important observations about them. They're new, they're a transplant. Big money is involved. We're talking about billions of dollars. And we're also talking about high stakes innovation issues. So whoever captures those billions of dollars from patent infringement damages may also be able to apply that to R&D. And final point is that China generally issues lower value damages than other countries. In one case, it was 1/18 of a German judgment. So there's a lot of money and a lot of differential in potential outcomes, depending on which court succeeds or how the court cases affect settlements, which is where most of these cases end up. But we're not going to talk so much about anti-suit injunctions as much as we're going to talk about the WTO's role in requesting China to be transparent about those decisions. And that's where we get to my PowerPoint. Okay, so the WTO's role in interstate IP disputes, the example of China. Let's see. Not moving forward. One second. Okay, so we're talking about Article 63, which I just mentioned. There are two legs of Article 63, in Section 1 and Section 3. They're a little bit different, and I believe they're in the materials that were distributed for this session. But the two important aspects are that laws, regulations, and final judicial decisions of general application are supposed to be published. And second of all, under Section 3, if a WTO member believes that a specific judicial decision affects its rights under the agreement, it can request another member to make that decision, or at least details about that decision, available. Finally, under the first sentence of paragraph 3, each member should be prepared to respond to a written request under Article 1, or there's no specific obligation to actually respond, only to be prepared to respond. Typical kind of WTO drafting, unfortunately. So this three-step process is: requester has the right to ask another member about a specific decision affecting its rights, or a recipient country should be prepared to supply to the other member a final judicial decision of general application. Whatever general application means. This is a WTO GATT language. It goes back to the late 1940s, if not earlier. There's some questions about interpretation clearly implicit in this, the vagueness. What is a final decision? What is general application? Why is there an obligation to give access or respond? No specific obligation to give access or respond, only to be prepared to supply. How does the VCLT, the Vienna Convention, fit into this? Is there a good faith obligation to respond to a request, because it's not specified in the text? As an affected country, you have a question about the Chinese legal system. China typically does not publish non-final judicial decisions. So the leg of Article 63 that would give you access to final judicial decisions in general application could have limited effect. It's been tried twice before. to demonstrate non-compliance. The US tried it in 2007 in a IPR enforcement case, DS 362. The cases are a little hard to, it's a little hard to locate these requests because they weren't necessarily part of the formal dispute. They were part of the buildup of the dispute. Also, if you're looking for specific decisions under that third leg, that second leg under paragraph 3, you're going to have a little bit of problems because foreigners actually rarely use the Chinese IP system. They're about 1% of total cases. The foreign docket, I think we're probably down to about 0.5% at this point in time. So if you want to get an understanding about the overall process, you're going to have to use something other than the specific decision affecting your interests. You're going to want to know about cases in general. So it makes it a little bit awkward to fit in. Regarding the duty to respond, so that's the easiest to look at. Here are two observations, two letters as part of the earlier docket under Article 63 back in 2006, and then the more recent September 7th, 2021 request. The first one was the US request. The US kind of had a blunderbuss request of China, basically to produce every case that it had involving intellectual property since it joined the WTO. This was a huge request. I don't even know how the United States was going to absorb that information, literally hundreds of thousands of decisions. But the US position was, hey, China, you have statistical data you presented at the WTO. Therefore, there must be underlying decisions. Give us a copy of them. It would really help us in either averting a WTO dispute about the adequacy of your enforcement mechanisms, or at least better inform that process. And China refused, saying there's no mentioning of a corresponding obligation of the requested member to actually follow the request. And the US response is, hey, look at BCLT, you have a good faith obligation to respond. That was never fully resolved. China did not respond. And the US position in that case was in fact compromised. In fact, the WTO panel, in looking at the adequacy of China's enforcement regime, said to the United States, well, you know, you have no cases that you cited in this dispute. You only relied on newspaper articles. And the US response was, we requested the case, China did not respond. What else are we supposed to do? Particularly in a non-transparent legal system. So really, I viewed that, and I was part of that process, to be fair. I was part of the USTR team, kind of lent over from PTO. But I think the WTO's decision was manifestly unfair and kind of insensitive to the dimensions of China's legal system and the lack of transparency that existed at that time. And then on September 7th, 2021, my 66th birthday, as it turned out, China responded that with respect to an EU request, much more limited, 4 specific decisions involving anti-suit injunctions. It again says, there's no obligation for us to respond, but in the interest of good faith, cooperation, and transparency, we'll give you some information. That information, by the way, was not provided multilaterally. It was provided, if at all, bilaterally. So the EU request is the one that focuses on anti-suit injunctions, Article 63.3. And the EU notes that there were 4 cases related to application for an enforcement of injunctions in relation to these high-value standards, essential patents. And some of these decisions also reference measures relating to initiating court procedures or license questions and royalty rates. So this appears to fall under the general application leg. And the EU says this appears to give a new interpretation to existing laws. Now, this was really of great interest to me because the EU, with the UK no longer being a member, is largely a civil law jurisdiction, and they're saying that courts are making law. So actually, I thought that was actually very persuasive, saying, you know, this extends beyond common law countries. Your courts are having decisions that are making decisions that affect us by virtue of their persuasiveness or their binding effect or some other reason. So what is general application? They don't say cases that are precedential in the TRIPS agreement. They say general application. As I mentioned, this is old GATT language. You have to go to customs and other decisions. And generally, as is true of many WTO GATT decisions, it really relates to giving information to business people, traders, or in this case, rights holders. Anything that applies to a range of situation or cases rather than being limited in their scope of application. It doesn't say binding. It doesn't say presidential. It says general application. So in my view, it doesn't indicate an intent to exclude civil law countries like China. Part of the EU request, again, to get to this general application notion, this was the final response of September 7th, is could China clarify what is the status of a big case? Because these cases were recognized by the Chinese Supreme People's Court as big or typical or a major technological case. So they're designating these cases as having some greater impact than general cases. And the courts have actually written them up and saying it's significant because of X, Y, and Z. And the Chinese response is kind of cute in my view. It said that these typical technology, big cases, have no legal effect of general application. Interestingly, they insert the word legal effect. The language is general application, not legal effect of general application. So I almost seem to be making the argument we're a civil law country, not a common law country. And that's how we view it. And then they go on to say these cases summarize trial experiences, strengthen publicity of the rule of law, and provide references for judicial practices. To me, that's general application. It doesn't say general application to the courts. It doesn't say to the judges. It just says general application to the public. Providing information to the general public, to me, is a general application. But again, this is unexplored territory. So the questions are, what is a legal effect? What is a reference for judicial practices? The Chinese argument. I believe the Chinese response nonetheless implied that its cases are of general application. And also politically as well, two really interesting questions. Although the US lost the earlier Article 63 request back in 2006 or 7, and the US, President Biden has said, we want to support the WTO, be much more multilateral, support our European allies. There was no support whatsoever for the US-EU position at the WTO this past summer. And why that is, I don't know. My friends at the government are not telling me. I think many of them are disappointed, but there was absolutely no support, notwithstanding the importance of this position to the Europe, the US, and to the TRIPS agreement in general. I should add as well that the EU position outlined two cases directly affecting American interests. One is a company called InterDigital based in Delaware that was the subject of an anti-suit injunction. The other one involved a case in the Eastern District of Texas between Ericsson and Samsung, two non-US headquartered companies, nonetheless have significant US business presence and a very important case in Texas. In addition, the Solicitor General did not make any appearance in the US case. And that case, Ericsson versus Samsung, to build on Don's previous observation about general lack of expert witness testimony, had three significant experts involved in it about the fairness of the underlying Chinese decision. Two former judges of the US Court of Appeals for the Federal Circuit, Paul Michel and Randall Rader, and one former chief judge of the IP Tribunal of the Supreme People's Court, who advised the court that there is no obligation to inform the other party of the motion for an anti-suit injunction or of the court of the final decision, of the parties of the final decision until it's issued and delivered. So raised some significant due process decision observations, and in fact, even the timing of that, the case that was the subject of the US anti-suit or anti-interference injunction was December 25th, 2020. So it almost seemed to be time for maximum disruption of US interests. So why is this important in China, and not just to the TRIPS agreement? There have been 160 standards essential patent cases in China from the period 2010 to 2019. Only 16 have been published. This data is largely derived from calling up courts to see if they've heard cases, have the cases been settled, et cetera. So you have a very low publication rate for these high value, high prestige cases. China traditionally awards much lower damages in these SEP cases than anywhere else in the world. And of course, there are these due process type concerns that have come to light that we really need some transparency over in order to engage in an intelligent way. Another reason that publication of cases is very important to China and to the world is that China is the most litigious society for IP in the world. Over 400,000 IP court cases last year. And in a sense, we're being deprived of this vast treasure trove of cases to the extent that not all cases are being published. And of course, it's very hard to make decisions about the fairness of the Chinese legal system, even if you have great experts like Don Clark just mentioned, if you don't have full access to the case decisions, if there's some cases that are missing. Also for China, it wants to become a global center for IP litigation. I think it's pretty hard to do this if you can't have access to the cases. And finally, and I think this is really of great interest to folks who are observing the Chinese legal system, China's been experimenting with a system of case law guidance. And another example really of civil common law merger, which really suggests that its cases are becoming, if they are not already, to some degree, cases of general application, notwithstanding the statement of the Ministry of Commerce at the WTO. So some closing questions. What role can the WTO play in determining if China is fairly implementing its WTO enforcement obligations, including whether foreigners are treated fairly? I think it's very hard to do that if China is not required to publish cases. The earlier 2007 WTO decision, which was largely adverse to the United States, is a perfect example of that. It probably would have gone in a very different direction if China had made the cases available and the WTO supported that under Article 63. Another question, and this has happened in trade negotiations I've been a part of, civil law countries will say, hey, this notion of general application, that only applies to you common law countries. It doesn't apply to us because we don't have a system of case precedent like yours. I think that's not an accurate observation. Also, by not requiring China to say, to produce the documents, China has more or less led a position that you can ask, but we don't have to show regarding Article 63, turning it more or less into a nullity. China also requested in the most recent one that the matter be handled bilaterally. I don't think that's an acceptable response. The whole point of the WTO is to make that information available plurilaterally for all members. And finally, I think the last point, which I think is very important in this context, is the TRIPS agreement has specific enforcement obligations. Unlike any other WTO agreement, it even has a criminal enforcement obligation, which is not found in any WTO agreement of any kind, that members have to have criminal procedures and remedies for infringement of trademarks and copyrights. And if you don't have transparency into that internal litigation system, then you're really hobbling the overall system generally. And I think it's far more important to have that level of transparency, I think, in IP, because it relies on internal enforcement mechanisms than in something like customs measures or access to markets. So this really has very broad consequences, not only for rule of law and conflict of law issues, but also for the value of the WTO in handling these contentious matters. And that's it for me.
Okay, thank you very much, Mark. And now let me turn things over to Professor Babb.
Thanks very much, and thanks, Don and Mark, for that introduction. I'm going to try to pick up on some of the points which both of you have made. So let me just share my screen here. Sorry, I'm having a bit of trouble with the share screening for some reason. I don't know why. Just give me a second.
This is the benefits and perils of doing this virtually. The benefit is we actually are able to have Professor Bath and Tsuyi Li, who are speaking to us respectively from Australia and Taiwan. But I think you made a breakthrough, perhaps.
Oh, have I? Well, I had it all nicely lined up there, but it wasn't. It's not actually behaving itself.
Mm.
We have one more try. Okay, is that showing?
No, don't see. You need to try the share screen again. If you've got your PowerPoint working, then try the share screen again and see if that works.
This is very annoying. Sorry.
Perhaps, should we, while you're, oh wait, that might work. Looks like you're close. So all you need to do is do the start slideshow, and I think you're good to go.
Are we now successful?
Yes.
Yes, sorry about that.
Okay.
Yeah, except your notes are showing up. So your
notes are showing up.
Your notes are showing. So we're seeing what you're seeing, but what you want to do is to have it some kind of different configuration so the audience doesn't see your notes. And just on the bottom right of your screen, you know, click that thing that looks like a no, it's not working.
Is that doing it?
No, you still have your notes showing.
If you don't mind us all seeing your notes, that's fine.
Yeah.
So let's just go
I
ahead.
would suggest just proceed that way, because at least we can see in part your, you know, we can basically see the main slide. So.
Yep. Well, I'm sorry about this. It doesn't usually do it this way, but that's the way we're going to do it. Okay. Now, essentially with the Chinese law in foreign courts, I've gone through various of the Australian, New Zealand, Indian and UK cases, and I divide them really into three categories. There are the civil and commercial cases, which Don has already talked about. There are what are the criminal related cases, which are really the extradition, refugee deportation cases, which I think are a separate category for various reasons, which I will explain. And then we have a final category, which is when what you have really is overlapping jurisdiction cases. Now, what we have with these cases is we have all sorts of various issues which are coming up. They're quite a bonanza now for private international lawyers, because I was amazed really at how many of them are cropping up. And they present all the usual issues that you get in private international law, you know, proof of Chinese law, private international law presumptions of similarity are the two systems the same? Can they be assumed to be the same for the purposes of evidence? Forum non-conveniens, issues like illegality and enforceability of contracts under Chinese and Australian law, the relevance of corruption and bribery, challenges to validity of the Chinese legal system, and so on. But I think that we can distinguish between the civil and commercial cases and between the cases which relate to extradition, refugee, and deportation, because as Don's indicated, the civil and commercial cases can be conveniently slotted into their own little boxes. So for enforcement cases, for example, in the Australian or New Zealand context, someone comes along and says, look, I've got a judgment from a Chinese court. The court says, oh, okay, that's good. Is there jurisdiction? Is there substantial natural justice, or can you prove that there was no natural justice in the case? And if you can't, which you generally can't, then they'll just go ahead and enforce it. So from the court's point of view, that can be actually looked at quite neatly, because as Don said, really they're just assuming that the systems are the same. And so to try and prove that a judgment should be not enforced because there's been substantial procedural unfairness, or because of corruption or bribery or official intervention, is really extremely difficult to prove. It's difficult to prove in any system, but essentially the court will essentially say, if you can't prove that there was an official who actually controlled the judgment, then you can't prove it for the purposes of contesting enforcement. But when we come to cases like extradition, refugee status, deportation, then you're actually talking about the freedom of individuals, particularly if someone's likely to be sent back and it's a death penalty case. And for this, the courts will look much more widely at the Chinese legal system. So say in deportation and refugee cases, the court will look at things like country reports prepared by the Department of Foreign Affairs and Trade. They'll look at country reports prepared by the Canadians, by the UK, by other countries. They'll look at international reports. They'll look at human rights questions. They'll look at the rapporteur and torture and so on. And they'll look at them a good deal more seriously. Now, obviously, more money is being thrown at these cases than is being thrown into the average civil case, which generally is a case between a couple of ex-Chinese citizens in the Australian New Zealand case. So a particularly good example of this, which I'm going to talk about, and which Don, in fact, has written on, is an extradition case which is still proceeding in New Zealand. There was a murder in Shanghai. Allegedly, or the Chinese authorities feel that it was committed by a New Zealand resident who was at that time in Shanghai and then returned to New Zealand. They put in a request for extradition about 10 years ago. There's no treaty between China and New Zealand, but under the New Zealand Extradition Act, it's possible to ask for extradition under the legislation in New Zealand, and this is what was done. The decision is made by the Minister of Justice, who made the decision. This was overturned in the courts. She then made another decision, and that is the one which is being currently fought out. And quite recently, the Supreme Court of New Zealand came up with a very lengthy and extremely well-researched judgment, taking into account all sorts of international instruments, examining the question of torture, examining the prospect of getting fair trials in China and so on, in order to make a determination as to whether this person can be extradited to China. But although the court has done a fantastic job in going through all of the evidence, it's become, I think, quite a good example of the difficulties of actually presenting or providing acceptable evidence on political aspects in the Chinese court system. Because the court accepted essentially that there was a risk of torture. They accepted that there was a risk of not getting a fair trial. And so the question was then, what would you accept by way of assurances from the Chinese government that a fair trial could be obtained? So if the New Zealand government was prepared to accept an assurance that there would be no death penalty, and there was some evidence that in other countries that assurance has actually been given by the Chinese and complied with, what assurances would you accept in order to show that you could get a fair trial in Shanghai in this particular case? And the court has come up with about 12 different ones. Now, It does raise, however, without going into all the details of all the things that they looked at here, the question of how far can you actually accept assurances? The court went through in some detail the question as to whether, if you have to ask for assurances, whether the assurances can be relied on. And they said, yes, there's a lot of authority to show that you, the mere fact you have to ask for assurances doesn't mean that you can't rely on the system. So they said, yes, we can ask for diplomatic assurances if we're satisfied that they'll be relied on. And then they asked themselves, can the minister reasonably conclude that there'd be no substantial grounds for believing that Kim would be in danger of being subjected to torture? And they said yes, if satisfactory assurance were received. And then they asked whether they could reasonably conclude that there was not a real risk that he would not receive a fair trial in the PRC. And they went through and they asked for and they received from the Chinese quite detailed assurances in relation to access to Kim once he was returned to Shanghai, if he is returned to Shanghai, that they would have be able to get access to him on 48 hours notice to make sure that he isn't being tortured, that they would get copies of interrogations so that they would be able to find out whether he'd been tortured or evidence had been forced from him. 12 quite detailed assurances as to how you would get a fair trial. But what they didn't look at, and this is where I think it's quite problematic and quite a difficult question, is the question of really, if you can't have a fair trial unless you have the assurances of this considerable detail, whether you can rely that there will be a trial at all. They were given material which about the judicial committees, which they were anxious about, but felt that potentially assurances could be obtained to make the conduct of the judicial committees satisfactory, even though they were concerned by the fact that the intervention of the judicial or adjudicatory committee would mean that the decision on the guilt of the defendant was being made by someone other than the collegial panel that heard the trial. But what they didn't really look at or give sufficient credence to, I think, is the suggestions that the defendant made that his ex-girlfriend's father, who was a senior Communist Party official, might have intervened in the case or played a role in the case. They more or less dismissed that out of hand. I did a little search, in fact, and discovered that the Communist Party is referred to only 6 times in the whole judgment. And one of those references is that the Commonwealth Party has given its commitment to the rule of law in China. So very few references to the role of the party potentially in the justice system. And the very curious aspect of it was that they relied on the work of Randall Perenbaum and a co-author in saying that actually most trials are probably okay in China. This is probably not a fair summary of Randall's work, but and that political trials were a small minority of trials. But what didn't seem to occur to them, or wasn't pointed out to them, was that by the time the Chinese government had spent 10 years trying to get Kim back to China, it was, to my mind at least, a political trial. And so overall, you have the question in relation to this sort of case as to whether the actual reality of how things work in the Chinese system is being communicated at all. Now, I see I've just about used up my time, but if I can have Martin's grace to sort of do make a few more comments. Now, I won't talk about the civil and commercial cases, although they are quite interesting. The other aspect I wanted to touch on, which follows on from what Mark was saying about the SEPS cases and so on, is the circumstances where the issue is not just that you have Chinese law, but that you have 2 courts which are actually dealing essentially with the same case. And there are quite a lot of these, particularly maritime cases, but not only maritime cases, where both courts, which have very wide admiralty jurisdiction, really do have jurisdiction over the same case. But cases where increasingly where you have overlapping jurisdiction being exercised by different courts in China. So one case is being run in the US, while at the same time another one's being run in China. And most recently, of course, we have all of the IP cases that Mark was talking about in relation to SEPS, where we have patent infringement cases going on in one jurisdiction, while we at the same time have a SEPS rate setting case going on in another jurisdiction. And of course, China is a relatively new entrant to this because the US, Germany, the UK, and so on have all been actively engaged in this sort of parallel overlapping jurisdiction cases for quite a long time. Now, when it comes to Chinese law itself, dealing with competing courts and cases is actually quite difficult. First, the Chinese courts have pretty sweeping jurisdiction, and in the IP context, they are in the process of expanding their jurisdiction in relation to international or foreign related cases. Chinese courts do not give up jurisdiction due to their extremely limited concepts of forum non-conveniens and the fact that under the Supreme People's Court interpretation, they don't have to pay any attention at all to another court hearing the same case until such time as a judgment has been recognized in China, which obviously won't happen if a Chinese court has taken the same case in the meantime. There's a limited recognition of exclusive jurisdiction clauses in contracts. And of course, you have combined with this limited enforcement of foreign judgments in China, as opposed to greater enforcement of Chinese judgments overseas, giving an incentive for people potentially to litigate in China. And the most recent aspect of this has been anti-suit and property protection injunctions issued by the Chinese courts, not just by the traditional issuers of anti-suit injunctions, in which I have to say the US courts are probably, US and UK courts are the market leaders so far. And so the Chinese Supreme Court has started, not just the Chinese Supreme Court, a number of Chinese courts, Shenzhen, Wuhan, and the SPC have started issuing anti-suit injunctions. And these have been actually extremely broad anti-suit injunctions. In the context of the set cases where most of them have come out, what we had was Oppo and Sharp, where the Shenzhen court issued essentially an anti-suit injunction against enforcement of a German judgment which had already been made. Xiaomi and Interdigital, an extraordinarily wide anti-suit injunction combined with penalties aimed at presenting litigation anywhere else in the world. And most recently, a higher order one in Oppo and Sharp. Now I wanted to look very, very briefly, Martin, at the Indian judgment in response to the Interdigital and Xiaomi case, which I thought was an extremely careful and systematic analysis of what you do when you get an injunction which essentially bars litigation of any kind anywhere else in the world. And it's the judgment in the New Delhi High Court was an extremely thorough and comprehensive commentary on the nature of the injunction issued by the Wuhan court and what you should actually do with it. And interestingly enough, the judge went through the anti-suit injunction itself, and it considered that certain matters that the Wuhan court thought were important were absolutely irrelevant in terms of anybody else looking at the Chinese injunction. One of these was the penchant for Chinese courts to emphasize that the plaintiff's behavior has caused great damages to the defendant's overseas markets, or alternatively, that the proceedings would impact the conclusion of a SEP license, which the Indian court considered was completely irrelevant in terms of an injunction. What they did pay a great deal of attention to, which I think follows the view of the US court in the Ericsson-Samsung litigation, was the fact that they considered there was no conflict, or there was no conflict between the case in India, which related to infringement of Indian patents, and the Chinese litigation, which related essentially to rate setting and potentially Chinese patents. So said the court, the cases were not in fact overlapping. They couldn't be overlapping, in fact, because the only place in which you could challenge Indian patents was in India. And therefore, insofar as the Wuhan court was trying to stop someone from exercising their legitimate right to litigate in India, there was no basis for doing that. So there was no basis for halting the Indian proceedings at all. Now, an interesting thing in the Indian litigation was that they disapproved very strongly of the way in which the anti-suit injunction was made. A copy of the ASI application was never provided by Xiaomi to the court. In fact, the court made the original decision in relation to the anti-suit injunction and then the later injunction without actually, it appears, consulting or allowing interdigital a fair opportunity to be heard at all. And the court very strongly disapproved of the way in which this had been done. So what they did, in a very broad-minded spirit, was they not only refused to give any credence to the Chinese anti-suit injunction, they issued an order against enforcing the anti-suit injunction, in fact, and to deal with the fact that the Wuhan court had backed up its injunction by ordering a daily award of damages, they decided that they would order that the defendant would have to pay to InterDigital an amount equal to any amount which had to be paid to the Wuhan court. Now, Xiaomi said this was very unfair because actually the fines, if they were paid, were going to go to the court. They weren't going to go to Xiaomi itself. The court said that someone has to pay.
Gideon, I'm going to have to ask you to wrap up because we're running out of time and won't have any time for Tsuyi. So my apology.
I'm wrapping up just now. Yeah. So I was saying the court essentially said, well, you know, you went for the anti-suit injunction in the first place. Someone has to pay the fine, so it will have to be you. You'll have to indemnify the defendants there. So I'll stop there and hand over to Xiaomi.
Okay, thanks very much. And so let's turn things over to Yi. All yours.
Thank you. Can you see my slide?
Yes.
Okay. Thank you, Professor Flaherty. I'm very delighted to share the semiconductor cases in the context of Taiwan, US, China trilateral relations. Semiconductor is a supply chain intensive and also IP intensive industry from the perspective of global network where trade secrets are embedded. The semiconductor cases can offer comparison as to how different or similar the three jurisdictions handle similar legal issues. First, I will briefly introduce Chinese law and policies in semiconductor sector. Second, beside the trade secret theft, I will demonstrate how cases may provide a basis for an economic espionage charge, and followed by some enforcement measures. And finally, I will use the Micron case to illustrate the points in the first and second parts, including how three jurisdictions control infringements. China has developed a comprehensive set of law and regulation to protect trade secrets. China recently in 2019 have made several amendments to the anti-unfair competition law, including burden of proof shifting and punitive damages rules. However, the history of China suggests that such amendment in provisions may not have had their expected impact, especially insufficient transparency like Professor Cohen's mentioned. So moreover, the trade secrets infringer envisioned in the 2019 amendment are private parties. Therefore, the law does not actually respond to the US criticism regarding the Chinese government's aggressive role in facilitating intrusion into American commercial networks. China has been aggressively ramping up its investment in domestic chip makers to reduce its dependence on foreign technologies. Despite massive injection of state investments, progress has been not that fast. On the other hand, Taiwan's chip industry ranks second only to the US. Due to the geopolitical tension between the US and China, China's semiconductor development has suffered some setbacks, and China has become more aggressive in poaching and targeting top Taiwanese chip talent to help them build a self-sufficient supply chain. According to the statistics, over 50% trade secret cases in Taiwan were committed by foreign parties, while 90% of the foreign infringements were from China. And more than 100 employees have been recruited from one single Taiwanese company, TSMC, by Chinese state-backed projects. Therefore, Taiwan had made major amendments to the Trade Secret Act in 2013 and 2020, adding criminal penalties and reciprocal principle for foreign national trade secrets, as well as regulations regarding foreign investment to protect Taiwan's assets. Cases, particularly where a foreign nexus to the alleged trade secret theft, may provide a basis for economic espionage charge in the US. For example, United States v. Liu in 2017, the appellate court upheld the conviction of a California businessman, Liu, and his company for various violations of the EEA relating to Liu's theft of trade secrets from DuPont and the sales of the trade secrets to the state-owned companies in China. And in this case, the court rejected the defendant's arguments for a narrow definition of trade secrets. Studies also show that in economic espionage case, a suspect may flee the country. And for some suspects, establishing a new life in a non-extradition country can be relatively easy, even preferable. For example, a Taiwanese defendant may commit a secret theft or some white-collar crime and flee to China because of similar language and proximity of geography and culture. And Taiwan has an agreement of mutual legal assistance in criminal matters with China. However, the practice has been not as effective as it is expected. In 2015, another semiconductor cases in Taiwan, a Taiwanese engineer working for a Chinese company recruited 7 current and former engineers in plaintiff's company with stolen trade secrets. They were promised an income 5 times higher plus sign-on bonus. 7 former employees were charged by Taiwan prosecutor. However, the main defendant fled and is still wanted. The US engaged in 2016 the DTSA, the Defense Trade Secret Act. One of the key policy behind the DTSA is protection of domestic trade secret from theft and misappropriation from foreign actors. For example, in 2019, the court denied a motion to dismiss filed by the defendant in migrant case. And the court filed for the plaintiffs on the lack of jurisdiction, personal jurisdiction issue, but dismissed the DTSA claims in part and only to the extent the wrongful acquisition of certain trade secrets predated the statute. And the court ruled that the other claims in furtherance of misappropriation and occurring after the passage of the DTSA were adequately alleged. Non-tariff measures like export control or a deny restricted party could have more significant effects on global supply chains than tariffs. Since 2018, more than 100 companies in total have been placed in the US trade blacklist, prohibiting most US technology to be sold to China without a license. The effect of restricted entities in semiconductor is not limited to tech companies only. For example, an exporter who wishes to sell or transfer a semiconductor material used in a fab process to a foreign restricted entity would be banned. The virtual monopoly on chip design and chip making equipment sector has given the US vast powers to control the flow of technology to China, even from non-US companies. Once the US puts someone on a trade blacklist, most of Asian suppliers will see it as a serious warning. And even if legally they could continue to ship to the blacklist entities, they will self-censor to stop doing it due to the political pressure. Therefore, multinational companies in semiconductor will need to react and adjust to the frictions arise from the above non-tariff measures. And these measures add uncertainty to the global supply chains and potentially turn a long-term supplier into an unreliable supplier. So we can almost summarize all the points mentioned above by the Micron case. And in this case, it's American chip makers' trade secrets were leaked to state-backed Chinese chip maker via a top Taiwanese manufacturer. This case was filed in Taiwan and US for civil and criminal prosecution, and the defendants filed IP litigation in China for injunctions. And with Taiwan authorities' help, the US government in 2018 indicted 5 defendants, including UMC, alleging a conspiracy to steal the trade secrets from Micron, a US company. And UMC is the Taiwan semiconductor foundry and the world's 4th largest contract chip makers. And the 3 defendants in the criminal case at the Taiwan court were convicted last year. Also in the same year, the UMC pleaded guilty in the US case to the criminal trade secret theft and will pay 60 million fine and will cooperate in the investigation and prosecution to its co-defendant, the Chinese state-owned enterprise, Fujian Jinhua. The Micron case also is another example of export control used in the global supply chain. When the Chinese court issued the preliminary injunction against Micron in 2018, banning some Micron's items selling in China. Later, the US government placed the Chinese company Fujian Jinhua on the US restricted entity list. And because the US has a mutual legal system agreement with Taiwan, the DOJ would obtain documents, records, and evidence information from Taiwan investigations. However, the UMC is now trying to prevent Taiwan court from applying its plea agreement in the US court. And the case is still proceeding in Taiwan. So in conclusion, with the trade secret laws and enforcement, the authorities from different jurisdictions sought to expand trade secrets owners' ability to protect their trade secrets, including against former actors. However, in the semiconductor industry, it is still hard to fully decouple the global supply chain involving thousands of suppliers from around the world that have tightly intertwined for decades. As trade secret protection in critical industries becomes more and more important for companies and governments, I expect more reliance on liberal democratic global allies to continue permanently in the future. Thank you.
Thank you very much, Suyi, and thanks to all the panelists. Let me ask Angela to post the CLE code. The panel was sufficiently rich that we don't have any time for Q&A, although I'm sure many people have questions. I would invite you, with the tacit approval of the panelists, to email them with your questions. But I hope that everyone came away from this panel with fresh ideas, food for thought, and I look forward to hearing myself from anyone with questions with regard to these issues as well. But once again, I want to thank all the panelists, especially those who joined us from the other side of the world. So once again, thank you all, and I hope you enjoy the rest of International Law Weekend. Thanks.